Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's incredibly significant judgment from the Supreme Court of India, 2024 INSC 813, a case concerning access to legal aid for prisoners. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns. We really appreciate your support.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now let's get started with today's case. This judgment, Suhas Chakma versus Union of India and ORS, tackles a crucial issue, ensuring that prisoners, particularly those from vulnerable groups, have access to free and effective legal aid. It's a landmark decision that builds upon decades of precedent.
Exactly, Priya. The case itself was a writ petition filed under Article 32 of the Indian Constitution, which guarantees the right to constitutional remedies. The petitioner, Suhas Chakma, argued that prisoners in overcrowded and unhygienic conditions are subjected to torture, cruel, inhuman, and degrading treatment, violating their fundamental rights. He also advocated for a permanent mechanism to decongest prisons. This is a broad-ranging petition, but the Supreme Court focused specifically on the issue of access to legal aid in this judgment.
Right. The court appointed an amicus curiae, a friend of the court, Sri Vijay Hansaria, a learned senior advocate, to assist in the proceedings. They also enlisted the help of Sri K. Parameshwar and Ms. Rashmi Nandakumar, representing the National Legal Services Authority, NALSA. This highlights the court's commitment to a thorough and comprehensive examination of the issue.
The role of NALSA is key here. NALSA is the body established under the Legal Services Authorities Act 1987 to provide free and competent legal services to the weaker sections of society. This act itself stems directly from Article 39A of the Directive Principles of State Policy, which mandates equal justice and free legal aid. The court's reliance on NALSA underscores the importance of institutional mechanisms in ensuring access to justice.
Absolutely. The court's judgment extensively reviews previous landmark cases that establish the right to legal aid as an integral part of Article 21, the right to life and personal liberty. Cases like Husainara Khatun, Khatri v. State of Bihar, Sukdas v. Union Territory of Arunachal Pradesh, Madhav Hayawadan Rao Haskot v. State of Maharashtra, and Sunil Batra all emphasize the importance of providing legal representation to indigent accused, even if they don't explicitly request it. The court recognized that many prisoners, especially those from marginalized communities, are unaware of their rights or lack the capacity to assert them.
These earlier cases laid the groundwork for this judgment. They established that a fair trial is impossible without legal representation for those who can't afford it. The court repeatedly stressed that the right to legal aid isn't a mere privilege, it's a fundamental right, essential for a just and equitable legal system. The court even quoted Professor Vance of Yale, highlighting the absurdity of a system that proclaims equality before the law but denies access to legal expertise to the poor.
The court also delved into the Legal Services Authorities Act, 1987, examining its provisions for establishing NALSA, State Legal Services Authorities, SLSAs, and District Legal Services Authorities, DLSAs. Section 12 of the Act is particularly relevant, stating that every person in custody who needs to file or defend a case is entitled to legal services. The court praised NALSA's efforts in implementing the Act, particularly its standard operating procedures, SOPs, on access to legal aid for prisoners and the functioning of prison legal aid clinics, LACs.
The NALSA SOPs are crucial. They outline the roles and responsibilities of various legal aid functionaries, including jail visiting lawyers, JVLs, and paralegal volunteers, PLVs. These SOPs aim to ensure that no prisoner is without legal representation, bridge the information gap between prisoners and the court, and address the specific needs of vulnerable groups within prisons. The court highlighted the impressive statistics provided by NALSA, showing the significant number of inmates interacted with and provided legal assistance to.
The court also discussed the Legal Aid Defense Counsel system, a more recent initiative by NALSA to professionalize legal aid services. This system provides dedicated, full-time lawyers to represent accused persons in legal aid matters, ensuring more effective and efficient representation. The court commended this initiative as a pioneering measure.
The judgment also addressed the issue of appeals filed by convicts. NALSA's data showed a significant number of appeals filed in sessions courts, high courts, and even the Supreme Court itself, thanks to the efforts of the plaques and the Legal Aid Defense Counsel system. However, the court also noted a considerable number of convicts who hadn't filed appeals, despite being eligible.
The reasons for not filing appeals were varied, ranging from satisfaction with the initial judgment to fear of sentence enhancement. Some convicts lacked financial resources, while others wanted to consult family or engage private counsel. The court acknowledged these complexities and directed NALSA to continue its efforts to reach out to these convicts and inform them of their rights.
The court emphasized the importance of awareness campaigns to ensure that prisoners are aware of their right to free legal aid. They suggested various methods, including public displays, radio campaigns, and even street plays in rural areas to reach the most vulnerable populations. This highlights the court's understanding that legal aid is only effective if people know it exists and how to access it.
The judgment also dealt with the undertrial review committees, UTRCs, which aim to expedite the release of undertrial prisoners who meet specific criteria. The court noted the significant number of prisoners released due to UTRC recommendations, but also highlighted the gap between the number of identified eligible prisoners and the actual number released. This suggests areas where the system needs improvement.
The court also touched upon pre-litigation assistance, emphasizing the importance of providing legal aid to suspects and arrestees even before formal charges are filed. NALSA's Early Access to Justice framework aims to provide this crucial support, ensuring that individuals are aware of their rights from the very beginning of the legal process. The court cited the case of Girish Gandhi versus State of Uttar Pradesh, which highlighted the problem of excessive bail conditions effectively negating the right to bail.
The judgment concluded with a series of directions to NALSA, SLSAs, and DLSAs, urging them to continue their efforts, improve monitoring mechanisms, and address identified shortcomings. The court also directed the registry to forward a copy of the judgment to all high courts, suggesting the issuance of practice directions to inform convicts about legal aid facilities when judgments are delivered. This ensures that the message of access to justice reaches everyone.
The judgment in Suhas Chakma is a powerful affirmation of the right to legal aid as a fundamental right, not just a procedural nicety. It's a call to action, urging all stakeholders to work together to ensure that every prisoner, regardless of their background or circumstances, has access to effective legal representation. The court's emphasis on awareness campaigns, improved monitoring, and the professionalization of legal aid services shows a commitment to making the system truly accessible and equitable.
And that wraps up our analysis of today's judgment. We hope you found our discussion informative and engaging. We tried to unpack the legal intricacies while keeping it accessible to everyone.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta, signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.